here. This is what I'm saying. I'm right here. I don't even understand it.
Okay.
Your town is like a time warp.
Okay. So I think you should call Janet Mistley. She's your lawyer. We're going to reset your sentencing that you missed on March 16th.
I'm not going to call her. Just sentence me. Just get this over with. Sentence me. I didn't do this in my right mind. Like, this is not who I am, and I just want this done. I want to move on.
So what we're going to do is enter a not guilty plea on the bond violation. The bond violation will be set at the same time as sentencing. I think we might be able to give you the date now.
That will be April 12th at 10 a.m.
April 12th at 10 a.m.
So I've got to sit in jail until April 12th? I'm sorry.
Well, yes.
Hang on, let me.
Because you failed.
I'm having a hard time hearing.
Yes, you failed. You failed to show.
So another fucking 30 days go find yourself!
Wait, yep. Okay. Go.
I'm fucking great. I hate it. I don't give a fucking why are you touching me like that? I cut myself. Wait, I cut myself. I can let myself down.
Just put her up against the wall.
Okay, I cut. You're breaking my arm. I'm not fighting you guys. I'm not fighting you.
Put your other arm behind your back. Do it.
Well, here. I got blood on it. I don't want to cut. I don't want blood all over you. That's all I'm saying.
What did you cut yourself with?
I don't know. I don't know.
My gun holster?
God, I don't know.
Yeah, we got gloves.
I just want to be sentenced. I want to be done with this. I'm so over you people.
I'm gonna call medical.
I'm bleeding.
Relax.
Just relax.
I don't even know what I cut myself at.
Oh shit. Where are you bleeding from?
My hand.
Oh, you punched something.
No, I didn't punch anything.
I think don't watch your record.
Oh, I thought I hit the metal on that. I didn't punch anything.
Stop.
Well, just hang on. Take a deep breath. Step over the cord.
Instead of dragging her down there, can we
Let's get her out of this room though, because she's tangling cords. That's all.
watch your step?
Got it.
They're on their way. Have her sit right here.
Just have her stand.
What are you doing?
She cut herself.
Drink water.
Hang on, just don't move your hand. Your hands.
Hey, please, that guy was booking it. Can you put him in the cell?
Will you hand me my screen box?
Bell Asset Management versus Danette Malik.
Ready, Your Honor.
Hello.
Hi, how are you?
I don't know.
Looking for every great recommendation I can receive from you today, sir. I have been in a very horrible assaultive position.
Okay, let me hold on a second.
Okay.
State your name for the record.
Danette Malik.
Okay, go ahead, Ms. Malik.
Well, I entered your courtroom honorably last year at this time. I came in as a plaintiff.
Okay.
And when I swore in, I gave some information about one company, Akram Rashid, merging with a new owner. At that time, I, the customer, was not given the respect, nor any other tenant in my building, underneath the laws to meet this person as a consumer. It is of complete responsibility for a new company to acquire the permission of the tenant where money is concerned to enter a good consumer relationship. This did not happen. Time proceeded, and this maintenance company decided to enter person's property with no permission, started to manipulate them, stealing possessions, stealing automobiles.
Ma'am, can I ask you something?
Sure.
Is this your motion to set aside the judgment?
Well, I did set it aside and we met that agreement. An attorney named Kevin Callahan sat in a court with me as a plaintiff. According to the law, there are no attorneys allowed. So I tried to motion in at the end of August because I recognized.
Hold on, no attorneys allowed where?
When I first met with you, Your Honor, I went into a small claims. And I was underneath the impression through the courses of the law that there were no attorneys allowed in a small claim. So something kind of got jangled up. I presented charges.
Ma'am, hold on.
Okay.
Okay, because I want to make sure that I've got everything in front of me. Was there a small claims case?
Yes. And at that time, we made an agreement.
Go ahead.
That after August, which was Akram Rashid's current lease, that there were not supposed to be any changes to, yet that wasn't the case. I would be on a month to month. I raised my right hand. Kevin Callahan, yourself, and I made that agreement. He swore to me, my mother, which then reported it to my banks. I reported it to my private attorneys in New York City that managed my work. And I contacted the courts. I talked to him verbally over the phone from his office in St. Clair Shores. And he stated to me that I swear, you're going to receive that sheet of paper. I waited and I waited and I waited. Spring and summer came to fruition and I called the courts. It's getting, later in the year. Where's the sheet of paper? It was as easy as that. There was no failure of me to make the payment. I still have the finances set aside. I feel like they are trying to retaliate against me because I've continued to make reports, which is my sole discretion. I have the right to do that.
You crazy as hell.
Between the Michigan State Police that were called on numerous occasions by other.
Ma'am, I'm going to have to stop you because I'm not clear what you're talking.
Well, I think that there's a position here where there's charges that he wanted to dismiss, but because he did not fulfill the obligation that he promised me, by August, I was being manipulated and they're not following through with the original agreement.
By whom?
I, yourself, and Callahan last January coming into February. We sat in the Zoom conference. I presented the paperwork that was unorthodox.
Judge, if I may, I have information on this.
And this change of ownership will not affect your lease agreement. She put unless otherwise indicated in your current signed lease. Well, unless otherwise means I can't do what I'm claiming I'm going to do. She broke these laws.
She being whom?
EJ Elizabeth Jefferson, who claimed to be a property manager that no one had ever met. There is no legible address. The Attorney General states that she's not a registered or licensed person. The federal offices told me not to be in business with them.
Ma'am.
Yep.
Stop. I'm going to tell you right now, you've lost me.
From the very beginning, I presented the first time I came in to see you. I presented both pieces of paper.
Stop for a moment.
Okay.
I had them pull a small claims case involving yourself against Bell Management.
Yeah, they did things that were illegal. Fair housing.
Ma'am, that was over a year ago. I would like to say I absolutely remember that.
Yeah.
But I don't.
I'm in dismay myself, sir, because I made that agreement with you. I clearly don't allow a judge or myself to be taken advantage of by an attorney's office.
Well, I don't know that I've been taken advantage of.
I believe I have been.
Okay.
I would not enter your courts to present this witness information as
Ma'am, stop for one moment. Let me hear, I've heard from you for a while. Let me hear from the other side.
Okay.
Mr. Callahan.
Thank you, Judge. Kevin Callahan, P78273, representing Bell Asset Management. The matter that Ms. Malik is speaking of was a previous matter, a small claims matter that was filed against my client in conjunction with a non-payment of rent matter that we filed against Ms. Malik. Those matters have been decided. Those matters are closed. It has no bearing on this matter whatsoever. This current case, Ms. Malik even admitted she's on a month-to-month tenancy. We provided a 30-day notice to Ms. Malik. She never showed up to court, so a default judgment was entered back in October against Ms. Malik. We subsequently filed a writ of eviction. That writ was signed by Your Honor, and now we get this motion to set aside that default 2 months after the default was entered, alleging that no attorney present and it was against her rights. And I'm as lost as you are with this, Judge. There's no basis to set this judgment aside. Ms. Malik is a month-to-month tenant. She has to vacate the property. However, I will say for the record, because I'm not going to let my reputation possibly be besmirched on the record here of doing anything illegal or improper, Ms. Malik has called my office and left over 120 voicemails accusing me of crimes under the federal law that don't exist, made threats against me, my family. Ms. Malik, I allowed you to speak. Please allow me to speak. She's made threats against my bar license. She's made threats against my family. She's made threats against my office staff. It has been deplorable what my staff has gone through with Ms. Malik over a situation that is a simple month-to-month termination, and Ms. Malik refuses to leave the property, Judge. We're just asking for that judgment to stand and the writ to stand so that my client can move forward.
Leave the property. I never made any threats to anybody's family. I never made any threats to anybody. I did call the office. I asked him for the sheet of paper that he promised. He said he would give me a month to month after August. I said, what is going on? I said, give me the oral confirmation or the written confirmation, and I'm going to continue to pay the money from August onward. I asked your court, I said, may I please have the sheet of paper?
Ma'am.
I did not threaten anybody.
Okay, fine. I don't know anything about that.
And
I'm not.
If he made an agreement about a month to month, why am I?
Ma'am, you have interrupted me numerous times.
I'm sorry.
That needs to stop.
I did not threaten anybody.
Okay. Fine. Always two sides to the story.
Rude.
But the reality here is you're before the court challenging, you're asking me to set aside a judgment to stay the writ.
She then told me, she flip-flopped with me 3 times. She put another sheet of paper underneath my door, asking me, E.J. Jefferson. She asked me if I abandoned my unit. Then she tried to take the money out.
Ma'am,
3
okay,
times
ma'am,
in September and October.
Ma'am, here's what I'm gonna do.
But there was no order.
Ma'am, I'm gonna pass
She
the matter.
asked me to move out.
Quit interrupting me.
Yeah, she's
Quit
still trying to take the money.
interrupting me. That's warning 2. On the third one,
electric chair.
I act. You're before the court to set aside the judgment and the writ.
Yes.
So that the record is clear, the judgment was entered for failure to appear at 2 hearings. First one being October 6th, and then on October 20th. I issued of 2023. I issued the judgment.
Because I thought that the month-to-month would be honored. That's all. That's all that he gave me. It was all the information I went by, was what I was sworn in. When I'm underneath oath, an agreement is made, nothing happened other than me calling his office and asking for that sheet of paper. I diligently, respectfully, and responsibly,
Ma'am, you can have a seat before I find you in contempt. That is now the third time that you have interrupted. Have a seat. Counsel, just wait. I will read the case at some point.
Oh, thank you, Judge.
Court recalls the case Bell Asset Management versus Melee.
And for the record, Judge, again, Kevin Callahan for plaintiff P78273.
State your name again, Miss Melee.
Danette Mellick.
All right. Let me, before anybody else says anything, because this is going way far afield. The only issue before me is the order that I issued in October, which was the judgment, and then the writ of eviction.
Well, I failed the October. I don't know how. I got confused. I'm not accustomed to the courts.
Ma'am, but if at any given time, here's what the problem for you, Miss Ma'am, and I'm just going to be blunt about it. That judgment went out from the court shortly after my signing. All right.
Sir, may I ask something of you? Once an agreement is made in court, isn't that you respectfully gave me the month-to-month. He told me if I dropped the charges on his group, his client would agree to give me a month-to-month. I mean,
then you're going to have to file a new claim that alleges that. That's not before me.
That's why I motioned in August.
No, but that is not before me today.
This is how I will state it.
No,
wait.
Won't.
Well,
That's not before me.
I can pay the money. There was never a failure. I swear I had the money aside.
They want you out.
I didn't.
It's not about the money.
They asked me to pay. There was no probable cause in any level. I called his office respectfully. I asked him for the sheet of paper for the month-to-month that was agreed upon after August. She put a renewal underneath my door. If she wanted me to leave, why was she sending me a renewal? She tried to take the money out in September and October. That would mean I'm still on a month-to-month. I just said, where is the paperwork to confirm that? My bank has it on the record, JP Morgan Chase, September and October.
Ma'am, they want you out.
But she asked me to renew.
Ma'am, I don't know about any of those conversations. They have properly been granted a judgment for possession. They properly filed the writ or the order of eviction. I've signed the order of eviction. There is no basis, and I've listened to everything you said to me. There is no basis for this court to set aside that judgment or to stay the execution of the order of eviction or the writ of restitution. There's no legal basis for me.
I can't pay the money that was agreed upon?
They don't want the money.
Even though she tried to take it out in September and October.
This is a termination of tenancy case. I don't know anything that they've done regarding taking it out. This is
They did.
termination.
They tried to take the money out.
Okay, ma'am, that's fine. I don't know that. But even if that were true, The judgment in this
What did
case,
I have not done anything though, Your Honor. I mean, this is against the law. I
no, what would be against the law is me to grant your relief you're requesting. Because they, like you have rights, they have rights. You brought this before the court. And I'm going to say it again to you, so hopefully it'll sink in. They properly got a judgment. Upon properly getting that judgment, they properly requested an order of eviction. I issued the order of eviction. That order of eviction, the judgment, because you have not provided a basis that will stand. Your motion.
I did nothing after August other than oblige where a month to month was concerned. That was the agreement. I did not refuse payment. There was no probable cause. She put a renewal underneath my door. I says, well, where's the sheet of paper if you're trying to renew? And then she's flip-flopping back and forth with me. Well, I'm like, okay, I thought I was supposed to be on a month to month. That's all it was. She lied to me. And then she lied to me again. And then she tried to take the money out 3 times. So it got me confused. I'm like, well, then am I on a month to month? The bank has that on record. So I came in thinking that if I spoke the truth, because I was sworn in last year and it was agreed upon that I'd be on a month to month after August. That was it. It was as simple as that. I contacted your courts on numerous occasions prior to the end of August.
Ma'am, maybe you don't understand. I just issued my ruling. Your motion is denied. What I will indicate is that the escrow will be held for 15 days and then it will be released back to the defendant. I will not pay the escrow over to the plaintiff. It will be released back to the defendant in this case. Thank you.
So what is the
Thank you,
time
Judge.
frame? May I have till the end of January, sir?
No.
Ma'am, you're operating on borrowed time. I signed the writ
I cannot just
December 3rd. I signed the writ December 3rd.
to have a moving truck in, please, sir. I mean, it is the dead of winter. I have no problem moving out. I've been looking for another place because I don't trust these people. First, they're making an agreement with me and then they're flip-flopping. Could you please, a little courtesy where this is concerned, please?
No.
You've not granted me any courtesy in terms of your talking. Why should I grant you any? But despite that, the writ will not execute prior to January 16th. So I will give you that grace of 10 days, and if I hear anything else, I may take that.
So I have to be out of this place by January 16th?
They cannot execute the writ prior to that date.
Okay,
Because otherwise they could do it tomorrow.
right.
I am giving that 10-day, I'm giving you that period. I'm not giving you to the end of the month. I'm giving you that period. That's as far as I'm going. I'm done.
I don't know what I did. And I feel swindled.
Are you on drugs?
Judge, should I enter a order to that effect or will the court? produce
Yes,
the
sir.
order?
Please.
Okay, thank you. I will
Prepare an
email.
order under the 7-day rule, please.
I'll do that.
Thank
Thank you,
you.
Judge. Have a great day.
You do the same, but too late.
The escrow itself, when does that get repaid to me?
You need to listen to what I just told you. 15 days, I will release the escrow back.
May I enter a bank account number or an
No.
address to you?
No,
I have to give you a different address because if I'm not going to be living here,
ma'am, you can give it to the clerk's office any day. I'm done. You need to leave my.
All right, good morning. We are on the record in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit courtroom. It's being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In Re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as arraignment attorney on behalf of Beth Bridgman.
Although I will represent myself.
Yes,
Okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
You'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So
but
I am
now's
waiving
not the time.
I am not waiving any of my rights.
Ma'am. Okay, thank you.
Ms. Bridgman, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I would pull the chair up, so thank you.
Well, then, if you want to sit there, I have no problem. All right.
Thank you.
All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it. Says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a statute.
What is MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know, well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine. That's the maximum penalty for both of the contempt citations. Ms. Bridgman, do you comprehend the rights that you have that I outlined for you and the maximum penalties I outlined for you?
I think that I would like to wait. I have a call into the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause. And she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the State Attorney General's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court.
See what I mean? Not very bright.
And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Ma'am,
Now,
just understand what the judge asked you regarding those two charges.
Did you just understand that I think there's a bigger overriding issue? Thank you. Thank you.
I'm not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already.
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between you and Ms. Bridges.
I just like to, state that.
Well, I think we need to back it up.
Pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future hearing.
No, but all of my rights were strongly impinged upon for even when I never failed to appear.
Okay, we're going to have a hearing where you.
She was working.
Okay, you're going to get your.
Mr. Villanueva,
no, this is.
Stop arguing with Ms. Bridges.
Okay.
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized show cause.
All right, if she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
well, she was investigating. Okay.
Today's purpose is to advise you of the 2 contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask what statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay, it does not say.
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
Why have they changed, Judge?
I'm not answering that question.
Can the prosecutor?
No.
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes,
okay.
I do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse, then I'm going to appoint an attorney. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know. I listened to that with Trevor's case.
All right. So I'm asking you, and you saw what
happened. How can I do?
Ms. Bridgman. So I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximum penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and over $7,500 fine. You understand it.
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gaffier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a common law thing.
It's not about anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty. That's correct. Okay. All right. So we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again if you want.
I don't see where there's a code or a statute or any law that I have actually violated here.
Are you high or just incredibly stupid?
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now.
What one do you have?
And this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva.
There's two items check marked here.
This is after the fact. So then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do.
Right.
Okay.
All right.
Now,
I'm going to find that.
Please, Judge Gothier.
Sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would you like to see what she has here?
I just,
okay. So how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Your Honor, what is the date of the first show cause?
December 20th.
No, December.
Oh, sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do.
Okay.
That is a hearing date. Today we're going to schedule a hearing date and you can present that evidence at that time.
And how will the hearing affect a trial by jury?
As I told you, there is no right to trial by jury
for a contempt charge.
So
so this is a perfect, nice little tidy package for everything. I see. Okay.
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Okay, did she seriously just say that?
Why is that?
I need to get to some of the documentation and follow up with that state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th. Then that gives you 3 weeks.
Thank you.
So we'll schedule this for contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long as I'm convinced that you're doing so of your own free choice, that you understand what's going on and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath, yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own. So if you want to subpoena somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena, they would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant, but everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out today.
Well, that's a lot of overnight in being arrested downtown and everything for misunderstanding that I would like to.
Ms. Richmond,
okay, I get it, Judge Gothier. I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
See that? That's your IQ, buddy. 0.
All right, so the
not the codes and statutes
is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Bridgman is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Bridgman's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training and researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been down that path before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yeah, Ms. Bridgman, if you want to represent yourself, it's a little bit more work.
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with.
You serious? I just told you that a moment ago.
Or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right.
sort out those
Thank
legal
you.
Arguments and the prosecutor will present witnesses at that hearing and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf, submit a subpoena to the clerk's office that I would review. It'd be the district court office.
Okay.
That I would review and I would issue the subpoena.
So one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association. Am I correct?
That is correct.
Yeah. Now.
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range of
I get it,
charges
but I appreciate that this is very big in scope and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so I have to know what the perception is there. So thank you. I appreciate any clarification.
I do have to follow what the any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
She's not going to come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you what you want to present. If you're going to represent yourself, you have to decide how you want to present your case. But I'm giving you the extra time you've asked for.
So this is a major judicial review, okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights.
And most of what I talk about actually falls under common law because it's common that anyone could understand it.
You done lost your damn mind.
All right.
That's why it's called common.
Set the hearing date.
Okay.
We'll arraign you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance or whether you should be required to post a bond before the next hearing. So I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller.
Your Honor, I would object to a PR bond in this case first because of her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had that date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have a concern about her appearance at the next trial, the next date.
All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing or whether...
I showed up at 9 a.m., Your Honor, and anybody could call me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? That's the arcing question here, I think. And I think a lot of people
Well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor,
I also know we don't have a lot of
Your Honor.
judicial review.
So
Your Honor,
as
part
the
of
bond
the-
question, any input, Mr. Villanueva?
Yes, I guess, I know you've just released me as the attorney of record, but I guess in support of the bond on her behalf,
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability. So she informs me, I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and she reports that she has no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor. Oh, and one last thing, she's a politically active member in the community. She has audited an election previously, so I believe she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
No, your name Dum Dum.
Well, they didn't.
It wasn't an offer, it was an order.
Sorry.
To appear.
They didn't actually hand it to
People
me.
just refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety of the full amount. There'll be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know if you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm going to go today, Mr. Bridgman. So we'll see you on the 25th.
We will look at the case law.
That's right. All right, we'll adjourn.
Success.
This way.
I know. She's only up here from North Carolina.
Work with all you guys on true crime television.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am, can you hear it?
No, I know.
Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that sees the drink.